Ladies and gentlemen, welcome to the Scarman Lecture 2015. This is a particularly special occasion for the Law Commission because it marks the 50th anniversary of the creation of the Law Commission by the Law Commissions Act of 1965. 2015 is, of course, a year of anniversaries. While we would not suggest for a moment that the Law Commission's 50th birthday is in any way comparable with Magna Carta or Agincourt or Waterloo, we do believe that its achievements over the last 50 years are worth celebrating. And it's a great pleasure to see here this evening so many people who've made important contributions to the work of the Commission over the last 50 years. The Law Commission is extremely fortunate in its founding fathers, Lord Gardner and Professor Andrew Martin, and in its first chairman, Lord Scarman. This series of lectures was established to commemorate Lord Scarman's work at the Law Commission and his promotion of the cause of law reform in England and Wales. It's a particular pleasure to welcome this evening Mr. and Mrs. George Ritchie. Mr. Ritchie is Lord Scarman's nephew. George and Anne Ritchie have attended every one of the Scarman lectures. You're very welcome. This evening's lecture would not have been possible without the support of the Legal Education Foundation. We're very grateful to its chairman, Guy Beringer, Queen's Counsel, and its governors for their very generous support. The lecturer this evening is the Right Honourable Sir Geoffrey Palmer, Queen's Counsel. In addition to most distinguished careers as a barrister and as an academic lawyer in New Zealand, Australia, and the United States, Sir Geoffrey has held many high offices of state in New Zealand, including Prime Minister, Minister of Justice, and Attorney General. He was responsible for the creation of the New Zealand Law Commission in 1986, and between 2005 and 2010, he served as its president. He is currently a Distinguished Fellow of the Victoria University of Wellington. Sir Geoffrey has been a leading proponent of the cause of law reform over many years. His subject this evening is the Law Reform Enterprise, Evaluating the Past and Charting the Future. And it's a great pleasure to welcome him to deliver this year's Scarman Lecture. Sir Geoffrey.
Eina iwi o te moto, tēnā koutou, tēnā koutou, tēnā koutou katoa. My lords and ladies and gentlemen, it's a great privilege for me to be invited here to deliver this lecture. It is perhaps a reflection of the common law tradition that resonates still for a New Zealander to be invited to deliver this lecture on law reform in London, and in such a wonderful hall as this. Of course, the occasion, as David said, is the 50th anniversary of the passage of the Law Commissions Act. And of course, then we lived in the twilight of empire, where the legal connections were deep and they remained influential long after the trumpets had fallen silent. The Commonwealth has kept the common law tradition alive, and the institutions of law reform devised in the United Kingdom were imitated to a remarkable degree in many countries, but not in that most big common law country, the United States. There, the American Law Institute and the National Conference of Commissioners on Uniform State Laws are essentially private organisations. Law commissions, or their kindred institutions, exist in more than 30 Commonwealth countries. They also occur within Australia and its states and the provinces of Canada, but no longer the federal Canadian government. That commission was effectively abolished twice. Agencies also exist in Ireland and Hong Kong, and there's been a proliferation of law commissions within a relatively short space of time. That must have been, I think, in response to a widely held view that something was wrong with the state of the law and needed putting right. Teaching the law of torts in American law schools in the 1970s and again in the 1990s, I reached the view that at least in the common law of torts, legal doctrine was more unified within the Commonwealth than it was within the several states of the United States. Further, American courts were much more active in fashioning new common law remedies, such as strict liability for dangerous and defective products, than were the courts of the Commonwealth. Legislatures, on the other hand, were more active in the Commonwealth than within the United States in reshaping and recalibrating the law. And in no area of tort law was that tendency more strikingly illustrated than in New Zealand's no-fault reform of personal injury law. This substituted a state scheme of earnings-related compensation for damages actions in the courts, and the change resulted from a 1967 report of a Royal Commission chaired by Sir Owen Woodhouse. It was the first law reform project I worked on, and it infused in me a permanent taste for big, ambitious law reform. The career of Lord Scarman illustrates markedly the preference for legislative solutions to repair the law compared with pushing out the boundaries by the methods of the common law. That point was emphatically developed in the Scarman lecture delivered in 2006 by my Australian friend Justice Michael Kirby. He characterised Lord Scarman the judge as a traditionalist rather than a creative judge. The ultimate way to justice in Lord Scarman's view was not by departure from precedent, but by legislation. Scarman, as a law reformer, as the first chair of the English Law Commission, showed strong and powerful reforming tendencies. Indeed, as early as 1974, in his Hamelin lectures of that year, he championed acceptance of the idea of a Charter of Fundamental Rights and Freedoms. And I confess that I owe Lord Scarman a debt of gratitude. The New Zealand Law Society Triennial Conference in Rotorua in 1984 was held a few weeks before the general election of 1984. And as deputy leader of the Labour opposition, I gave a paper to that conference to promote the idea of a Bill of Rights for New Zealand. I was fortunate enough to share the platform with Lord Scarman, the ranking overseas visiting judge. His contribution to the conference was downright, and it was extremely helpful to my cause. He told the conference that the United Kingdom had historically enjoyed a very successful constitutional system, but it was, quote, showing signs of bursting at its seams, close quote. His solution was a Bill of Rights founded on the European Convention on Human Rights and Fundamental Freedoms. He made at that meeting both a legal case and a political case for taking that step. The New Zealand Bill of Rights Act 1990, enacted as an ordinary statute, had life breathed into it by the New Zealand Court of Appeal, especially under Lord Cook of Thorndon. The New Zealand model was influential in the United Kingdom's decision to enact a Human Rights Act 1998. Constitutional change, of course, is not easy to achieve, especially in countries with flexible, uncodified constitutions such as the United Kingdom, New Zealand, and Israel. The constitutional outliers on this planet. Indeed, I believe Lord Scarman would not have approved of a retreat from the Human Rights Act 1998. I come now to the original vision. Any analysis of law commissions, their performance and their future must confront the awkward issue of politics. Reforming the law requires legislation. The making and passing of legislation is central to the law reform enterprise. Only the state can make legislation, and the making of it is critical to the framework of any legal system. While not every activity of a law commission requires legislation, the achievement of its fundamental purpose does. Who makes legislation, how they make it, and where a law commission fits into the legislative system becomes a critical issue in charting the future. Recently, a law commissioner from England and Wales, Elizabeth Cook, who I'm happy to say is here today, and she's becoming a judge soon, so that's a loss to law reform. But she's written that the dream of the 1960s was of, quote, a law reform body unconstrained by politics, close quote. Politics speaks the language of priorities. The clash between legal approaches to the reform of law and political approaches lies at the heart of this lecture. My thesis is that each realm has lessons for the other. I have played on both sides of this street, and I hope to bring insights from each for your consideration. The conclusion that emerges from all this revolves around parliamentary reform. In order to reach this somewhat ambitious destination, I'll traverse the original vision surrounding the Law Commissions Act of 1965, make some general observations on the performance, then move to an analysis of the lessons that can be extracted from the experience, concluding with some suggestions about what should happen next. We should start, I think, by what is meant by the term reform. The expression law reform has no precise meaning. To reform something is not so much to form it again as to change it. Reform is the amendment or altering for the better of some faulty state of things. The idea of reform carries the prospect of controversy over contestable ideas. For some, reform is a road to ruin. Things are bad enough already, and anything that is done is likely to make them worse. Reform is not the exclusive province either of law's empire. Improvement in the law can come about in many ways. Legal evolution and change are inevitable. Law must respond to social and economic changes and provide a framework for future development. Law reform, I think, is attached to the idea of progress. The provenance of the Law Commission for England and Wales flowed from the activities of Lord Gardiner, Lord Chancellor in the Wilson government, elected in 1964. In 1951, Glanville Williams edited a book entitled The Reform of the Law. 12 years later, the Society of Labour Lawyers sponsored a new book on the same lines as the 1951 book, and it was called Law Reform Now. The opening chapter dealt with the machinery of law reform and was co-written by Gerald Gardner and Andrew Martin. The book had a number of leading contributors who discussed the case for reform across different areas of the law, but it was the opening sentence that attracted attention. I quote, "We think we are justified in treating as axiomatic the proposition that much of our English law is out of date, some of it shockingly so. The fact that this view is shared by the overwhelming part of the legal profession is significant, for taken as a whole, no profession could be more conservative." The public, they said, did not campaign for change because the system is not only unknown to the community, but unknowable. The problem of keeping the law up to date was, in the view of the editors, largely one of machinery. It was necessary to subject the whole of English law to review, they said. Where the case for reform was made out, Parliament should be presented with concrete proposals and given adequate time to deal with them. The authors reviewed the machinery, finding it not geared to steady, planned and coordinated operation. The solution advocated was to strengthen the Lord Chancellor's office by establishing a new unit presided over by a Minister of State called a Vice-Chancellor, and he would be exclusively concerned with law reform. The Vice-Chancellor would be responsible for a committee of not less than 5 highly qualified lawyers to be called Law Commissioners. They would be full-time, appointed for 3 years and eligible for reappointment. They would be recruited from among the practising and academic lawyers of exceptional merit. The commissioners needed a legal staff, including skilled parliamentary draftsmen. The chief responsibility of the law commissioners would be to review, bring up to date and keep up to date what might be called the general law, the common law, equity, and also parts of statute law which do not fall within the province of government departments. For the most part, commissioners would not be concerned with those parts of the law, but generally the commissioners would be free to roam widely and take up proposals from the public, commerce and the professions. They went on to say, the authors, that there was a strong case for progressive codification of English law, and indeed they said it was overdue. The state of English law was so deficient that codification would have to be preceded by reform. But codification should have second place because changes to the legislative process were also called for, and the government should be required to find parliamentary time for consideration of any report that recommends a change in the law. The proposal, somewhat altered, did reach the statute book quickly in 1965. It featured as part of Harold Wilson's strategy of modernisation, forged in the white heat of technological revolution was the term used. Law reform appears to have been a significant feature of the winning election campaign of 1964. I doubt that it ever has been since. A short white paper was published on the proposal and the parliamentary debates disclosed support for the idea. A Scottish Law Commission also eventuated, but that was due to the advocacy of the Secretary of State for Scotland. It wasn't in the 1963 book. And what the white paper did was to propose both English and Scottish law commissions, and the statute passed was commendably brief, perhaps too brief to prevail over the forces within the executive government intent upon taming the vision. Perhaps significant, indeed, was the omission of the Minister of State that featured in the 1963 book. Both the commissions were infused with the same functions. They were enjoined to keep under review all the law with which they are respectively concerned, with a view to its systematic development and reform, including in particular the codification of such law, the elimination of anomalies, the repeal of obsolete and unnecessary enactments, the reduction of the number of separate enactments, and generally the simplification and modernisation of the law, and there were some other details. Now, the Commission was required to review the whole of the law from the angle of its systematic development and reform. It was to prepare and to submit to the Lord Chancellor programmes for examining parts of the law with a review to reform. The Lord Chancellor would approve the programme and lay it before Parliament. The recommendations were for the Law Commission. Whether the final proposal would go ahead was for the government. Thus, there was from the very beginning a tension between the Commission's independence and the implementation of its proposals. But law reform was transformed this way into a professional activity with a permanent institution staffed by full-time commissioners led by a High Court judge, so that the reputation and prestige of the judicial office was to be used in this context not in applying the law but in changing it. And it was to be resourced by the government, but the Commission was to be independent. I now move to the performance. The model was followed with variations in many Commonwealth countries. It's been successful because of the high ability of the people appointed as commissioners and the quality of their work. The fortunes of this model have waxed and waned over the years. It has even been suggested that, quote, institutional law reform began to unravel, perhaps because it no longer reflected mainstream political ideology. I'm far from convinced, however, that the popularity of law reform diminishes with Conservative governments, as has been suggested. Certainly in Britain, Lord Hailsham, as a later Lord Chancellor, expressed gratitude to Lord Gardiner for the machinery of law reform inherited, and he used it. He judged the commissions to be an invaluable mechanism for reform. The problem perhaps lies not so much in political ideology as in the determination of priorities. These fluctuate naturally. Since 1965, there's been a proliferation of public bodies that have an interest in law reform within specialist areas, and they make proposals for it. Law commissions have many competitors, and the mightiest of these are departments of state. There is invariably a shortage of money. Continuous funding of an independent agency will not occur unless the work product adds real value in the opinion of ministers. Evaluating the performance of law commissions therefore poses many challenges. There's no agreed methodology for doing it, although most countries have an external reviewer who reports on the agency from time to time. Law reform agencies have different functions from one jurisdiction to another. Some of them do much general advisory work. The diversity of function makes measurement complicated. Establishing key performance indicators in a way that is actually measurable raises difficulties given the range of projects and their different characteristics. Some projects are merely difficult, others are truly wicked. And the efficient and careful use of resources is easy enough to measure through the public audit process. Timeliness and meetings of deadlines is another item on which law commissions are often measured and sometimes criticised. Items such as public education, media exposure, internet usage, citation in the courts, all these can be gathered to show that commissions add value. But outputs such as reports produced, working papers completed, consultations and staff employed can also be recorded. Most agree that success doesn't depend alone upon the number of reports that are taken up by the government, although the agency must be sufficiently valued to survive the endless rounds of expenditure cuts that characterise all modern governments. There is no value to any government in fine academic analysis of a theoretical nature if none of the work reaches the statute book. Lord Thring, who in 1869 became the first parliamentary council appointed in England, apparently said bills are made to pass. That principle applies to proposals of law commissions. Yet when it comes to outcomes from the work, these are no easier to evaluate than Acts of Parliament. As President of the New Zealand Law Commission, I had some interesting discussions with the Auditor-General about how to measure the Commission's outcomes, since she did not attempt to evaluate the legislative work of Parliament. Looking at the history of the Commission of England and Wales over a period of 50 years as an outsider, it seems clear to me that the Commission has enjoyed fluctuating fortunes. The Commission started strongly with Lord Scarman at the helm, although codification produced little return. The Commission has been through patches of difficulty, but in other times it has flourished, as it is now. The 214, the Commission published 18 reports, 5 papers, and that is prodigious productivity by any standard. The rate of implementation of Law Commission proposals over a period of 50 years is impressive. As at May 2014, 202 law reform reports had been published, and of these 135, or 66.8%, had been implemented in whole or in part. Only 31 reports, or 15%, were rejected. 8 reports have been superseded by events. Changes to the Law Commissions Act made in 2009 by Parliament require the Lord Chancellor to report to Parliament annually on the government's progress in implementing Law Commission reports. A protocol has been agreed between the Law Commission and the government, and the result of that is once a report has been published, it has to be responded to, and that means that one important feature of the new arrangements is that a report must not be started unless serious intention to take any future recommendations forward has been expressed by the relevant government department. An interim response must be published within 6 months, and Parliament has adopted a special procedure for non-contentious Law Commission bills. And these changes have definitely, in my opinion, improved the situation, since the easiest motion in politics to move, in my experience, is a motion to defer. The projects upon which the Law Commission has embarked cover important areas of the law: criminal, family, tort, contract, equity, property, evidence, landlord and tenant, contempt of court, administrative law, limitations and consumer law. The diet has been enriched, but it has been limited, and the concentration has until recently been on areas that may, I think, loosely be called lawyers' law, although I've never been quite clear what that is. There have been projects where detailed and demanding legal research is required as opposed to policy research. I also hazard the observation that had the projects, some of them not been done by the Commission, it's doubtful they would have ever been done at all. That's not to say they shouldn't have been done, they should, but to progress any law reform project requires political commitment, sufficient resources and parliamentary time. And to secure these, remorseless advocacy has to be engaged in. Law reform mostly lacks political sex appeal, and it struggles in all jurisdictions, I suggest, to secure political priority. So the performance of the Commission within the constitutional constraints in which it operates has, I think, been brilliantly successful. When the Commission's work on statute law is added to the mix, the record looks even better. While consolidation of statutes is a difficult task, it produces better law, and the work on statute law repeals is essential in a jurisdiction like this, where Parliament has been churning out statutes from a time that the memory of man runneth not to the contrary. The Commission's been responsible for 222 Consolidation Acts. It's been responsible for 19 Statute Law Repeal Acts that have repealed 3,117 statutes in their entirety and 3,982 in part. But these days, nothing in public administration is permanent, and such institutions are vulnerable to changing fashions. Expenditure cuts, departmental scepticism is another hazard. The Law Commissions have recently been, this Law Commission has recently been reviewed and received a favourable report, both on the quality of its work and the value of that work, having at that time, I think, survived a heavy dose of quangoside. Despite the solid record, the Law Commission has had its share of critics. R.T. Urton, a former staff member of the Law Commission, published in 1987 a book called A Lament for the Law Commission. I studied this book carefully when it came out, because as Minister of Justice I had been responsible for the Law Commission Act 1986 there. Urton observes, the frustrations and disappointments of the job done by a member of the Law Commission staff were such as to make it unsuitable for anyone who was emotionally committed to the purposes for which the Commission was set up to fulfil. His main point was that the Commission had no power of its own because governments decide the fate of its work. The point can be relatively easily overcome by ensuring that the topics that are embarked on are ones which the government has an interest in pursuing, and that is now the case. But the Law Commission's activities have produced other critical observations over the years, and a book of essays was published after the 20th anniversary of the Commission, organised around the theme, Can We Do Better? and it found there were many problems. These centred around two things: the executive and Parliament. About the executive, it was said, government resists large-scale reform proposals from an agency over which it has no control. Government departments are wary of the Law Commission, and departments have an uneasy relationship with it. The responsibilities of departments for law reform were left unaltered when the Commission was set up, making tension inevitable and bifurcating the responsibility for law reform. The Law Commission tends to advocate for its proposals it needs to advocate more effectively for its proposals, and the degree of government control of the Law Commission was too great. On Parliament, it was said, Parliament has a chronic indifference and distaste for law reform. Parliament should reform its procedure to deal with law reform proposals in a better way. Pressure on parliamentary time means priority does not go to Law Commission projects. Reforming technical lawyers' law has no appeal to political parties or the public. Parliament and its procedures are outside the control of the Law Commission and subject to the control of the executive. There are no political rewards in passing consolidation statutes, and all reform projects contain within them the seeds of political controversy. And using law to improve society inevitably has ideological consequences as it involves the choice between competing values. Well, now all these issues have to me a familiar ring to them. Problems with the executive and Parliament are central to the vice in which all law commissions find themselves squeezed. The methods of making law in both the executive and the Parliament need to change. I want to say a bit about the Scottish Law Commission. It's naturally smaller than the one for England and Wales, and since constitutional devolution in 1999, the Commission has had a different focus. Most of its work now revolves around Edinburgh with Scottish ministers. And in the early years of devolution, a number of important enactments were made based on Scottish Law Commission reports, for example, land tenure reforms. Gradually, however, the rate of implementation dropped. The profile of the Scottish Commission has risen since the adoption of a new procedure in 2013 in the Scottish Parliament for dealing with reports. The new process reflects a common understanding that it is important to find ways in Parliament to consider bills that would implement Commission's reports. And of course, Scots law is quite distinct from English law, although sometimes the Commissions work on joint projects. And recent evaluations in the academic literature show positive evaluations of the impact that Commission has made. One former commissioner said in 2013, it's hard to overestimate the influence that the Scottish Law Commission has had on the evolution of Scots law. Consider, for example, property law or family law or criminal law or the law of diligence or the law of bankruptcy, to mention just some fields. Without the Scottish Law Commission, we would today be looking on a different legal landscape. So to conclude this section, in my judgment, the perceived difficulties faced by both law commissions established under the 1965 Act have to be acknowledged. The difficulties have not disabled the commissions, nor prevented their performing excellent work and securing valuable legal change. But getting a statute onto the books is much harder than anyone who hasn't tried it may believe, and the commissions may not have achieved the commanding high-level vision that launched them. We should, however, celebrate both commissions' real and enduring accomplishments, and we can learn from the experiences of both commissions and work toward the original vision, I suggest, in a different way. So we come to part 4. What are the lessons? Well, many lessons can be extracted from the rich experience of all law commissions, and I want to widen the frame of reference a bit here and rely on my own experience in Australia and New Zealand. Things have been done differently there. There has been perhaps less concentration on black-letter law and more engagement with social policy issues. The problem that law commissions were designed to deal with, I think, should be redefined. Law commissions have developed and utilised systematic methods for designing law. They often struggle to get their proposals enacted. And the analysis that I want to make will drive towards the conclusion that the experience of law commissions is indicative of a wider problem with how legislation is made generally, and that this problem needs to be tackled head on. We need to salvage from the original vision items that should remain on the agenda. And most notable of these is codification, to which I now return. And I'm now getting into that part of the paper that has nice little subheadings, and it becomes a little bit complicated now, so I'll mention each subheading as I get to it. It seems clear 50 years later that the law reform enterprise has not delivered on the wider vision and aspirations that were pursued in the beginning. And codification of the criminal law, the law of contract, and the law relating to landlord and tenant, as laid down in the Commission's first programme, hasn't really been achieved. And I want to say to you that the ghost of Jeremy Bentham haunts the English legal system and common law systems still. Bentham, of course, had no time for Judge and Co. He offered to codify laws for all countries professing liberal opinions because, he said, in every political state, the greatest happiness of the greatest number requires that it be provided with an all-comprehensive body of law, all comprehensiveness practicable and indispensable. Bentham abhorred Blackstone's commentaries on the laws of England, having heard Blackstone lecture at Oxford, and he had a much sharper eye for detail in the defects in English law than Blackstone had. Bentham wanted judges to make no law at all because all law had to be knowable and accessible. And if a matter was not in a code, it was not the law. He coined the word codification. One does not have to share Bentham's distaste for judge-made common law to appreciate that he was actually onto something. Scarman certainly believed in codification. He lectured at the University of Hull in 1966 on the topic A Code of English Law. Let me read you what he said. I have in mind enacted law which, while it may cover the whole legal field or only part, yet within the limits of its application is intended at the moment of its enactment to supersede all previous law, statute and judge-made. It differs from a comprehensive textbook in that it has in itself the authority of law. It is more than a mere restatement because where appropriate it will contain provisions modifying and reforming existing law. A code, however, while it will both revise and consolidate existing statute law, does much else besides. It reduces into statutory form all the law relating to the subject matter wherever that law may be found and from whatever source it may be drawn. Well, while in large measure codification failed, I argued it should be revived. New Zealand has had a criminal code since 1893. Canada has one. In 2006, after more than a decade's work by the Law Commission in New Zealand, the Evidence Act was passed, a measure close to meeting Lord Scarman's definition of a code. And despite being leery about it before it happened, the judges would now not be without it. Professor Rupert Cross observed in 1961, it is difficult to believe that codification of English law will not become a live issue within the next 50 years or so. An organisation with the characteristics of a law commission is, I suggest, an ideal one to engage in the drafting of codes, and there should be a recommitment to that task everywhere in the common law world. Few measures would do more to assist the rule of law. I come now to lawyers, legislation and policy. The intellectual training of lawyers and their methods of work, of course, has many strengths, but they don't fit in easily with the methods used in departmental policy shops or the methods of politics practiced by ministers. The differences of approach may have, the differences of the three approaches may have some explanatory power as to why tensions arise between governments and law commissions. The law, policy and politics all have their own methods and cultures. MPs and ministers speak the language of politics, negotiation, log rolling, persuasion and compromise. Civil servants speak the language of policy. Lawyers use the methods of the common law. And different methods have developed within the policy making of government departments over the last 50 years. Legal analysis and legal reasoning are not enough in the policy world. Lawyers and judges and their toolkit are a necessary condition in the world of policy making, but they are not a sufficient condition. Both these worlds have to learn from each other. The common law, of course, is the work of judges. It's based on precedent. And the common law proceeds by a process of inductive reasoning. It reasons from the particular dispute to a general rule, and it is inherently grounded in the context of specific fact situations. And while reform can be accomplished without statute, the future belongs to statute, not the common law. Statute now is not merely king, it is emperor. And the concentration has to be on the design of statutes, and that raises a whole range of different issues that common law methodology cannot address. How does one decide that policy will be contained in a statute? How does one assemble the support to get it passed? How can one demonstrate that what is proposed will be better than what went before? The truth is that the methods of the policy analyst tend to be those of Plato, not Aristotle. Lawyers, of course, have much to contribute, but many other disciplines are needed. The most critical legal skill, without which nothing else is possible, is the drafting of a bill. No policy proposal can properly be understood and tested unless there is a bill drafted by parliamentary counsel. And embedding parliamentary counsel in the Law Commission in London was a stroke of genius. Lawyers also have valuable contributions to make on the form of the law as well as its substance, the structure of government, the methods of public decision making, and most of all, constitutional limits. But it is also necessary to consider what Richard Posner has called the decline of the law as an autonomous discipline. As did Oliver Wendell Holmes, Posner argues that economics, statisticians, and other social sciences will have a far more prominent role in legal reform than has traditionally been the case. Social science data, pure science, empirical studies, statistical analysis, economic analysis, sociology, anthropology, and many other branches of the social sciences, depending on the subject matter of the inquiry, means that broad policy making is not the same thing as deciding individual cases according to law. Legislative facts are different from adjudicative facts. There is, though, this difficulty that law commissions have with what is called big policy. So I want to discuss lawyers' law versus big policy for a minute. In the legislative process at Westminster itself on the Law Commission Bill in 1965, it struck me as significant that most speakers in the Commons and the Lords thought that the Law Commission had to steer away from anything that was politically controversial. The lawyers in the House of Lords were adamant on that point. Lord Denning said, "I'm sure it would be wrong for a commission of this kind to take over broad questions of policy and the law, which must be the province of Parliament." I don't find that argument remotely convincing. After all, governments not infrequently set up royal commissions or independent inquiries to investigate and report on questions of broad policy. There are areas where lawyers will have more to contribute than in others, and technical issues such as the recent reform of the law of perpetuities is an example of that. But even in the most technical area, tricky policy and political problems can come up. In my own experience, for example, the review of the New Zealand Limitation Act raised the issue of how to deal with historical sex abuse claims. Big projects, including heavy social policy, can be successfully completed by law commissions, and this is particularly the case where the project touches upon several departments of state. I personally led 2 projects that resulted in massive changes to the law and required significant journeys into controversial areas of social policy in New Zealand. A revision of the entire law relating to the sale of liquor — we inherited a British drinking culture — and another on war veterans' pensions. On liquor, many departments had an interest, and those interests were often conflicting. We had at the Commission an interdisciplinary team of 8. We received 3,000 submissions, conducted many public meetings, and used digital technology to interact with the public. A respected New Zealand judge, formerly President of the Court of Appeal, Sir Ivor Richardson, who sadly died only just recently, characterised the New Zealand Law Commission in the following way: it is the statutory equivalent of a semi-permanent Royal Commission with a roving function. And that, I think, is a good way of looking at it. Law commissions properly staffed should not be reluctant to take on projects with big policy and social content, and nor should governments be reluctant to entrust them. It's cheaper than setting up a Royal Commission. So I want to say a little bit about the strengths of the Law Commission process, because lawyers have a lot to contribute in systematic methods of approaching problems and solving them. And it seems to me that in preparing their reports that have been adopted, law commissions have learnt a great deal about how to go about this task. It seems natural to lawyers accustomed to court rules to have a set of procedures for dealing with law commission projects. Systematic methods of problem definition, research and public consultation on the basis of issues papers are vital. And I think that law commissions produce legislation that is better thought through than that produced by governments, and I can say that from having been involved in both sides. Law commissions' statutes are more likely to work and last longer, and they are more rigorously tested before enactment. So I suggest in this paper 12 points as a rough guide about how to organise procedures to ensure that nothing is overlooked and all options are explored once a law commission project's been embarked on. The first thing is to set up an interdisciplinary team whose members have the skills, background relevant to the topic under review, and they have to be able to engage in heavy and long research. The second is to conduct discussions at the beginning with interested parties to secure their views on the topic under review and to do a literature search, both domestic and international. That will help you understand what the problem is. Then there is consultation. That's vital. Sir Peter North, an experienced law commissioner, described consultation as producing factual evidence as to the practical operation of the law, the provision of detailed technical advice, the creation of democratic legitimacy for any ultimate solution, the assessment of the weight of public opinion on social issues, and to flush out opposition. That last is particularly important. 4, publication of an issues paper or working paper setting out the research done, defining and contextualising the issues and framing the questions upon which submissions are sought. That will help the thing to have focus. 5th, design a communication strategy so that the messages reach those whose attention needs to be engaged here. 6th, take submissions from the public using the new media as a way of reaching and engaging ordinary people, and allow for some interactive engagement with groups and conduct public meetings that can have a lot of further insights. In the liquor project I mentioned, we had 50 public meetings around New Zealand. 7, meet with the relevant government departments and all the stakeholders, and meet with them even after their submissions have come in, to try and probe them and get further understanding. 8, encourage public debate through the policy development process, because that adds value and points to where the difficult issues are. 9, craft a final report, because that often determines the fate of the project. Really, the report is an advocacy document. Many drafts are necessary. The inclusion of a draft bill by Parliamentary Council ensures that the ramifications have been thought through. 10, the report should set out in detail the proposals, analysis of the options, why the preferred option was selected. It should discuss the methods of administration. The fiscal costs and economic impact assessments must be rigorously analysed and published as well. High standards of scholarship is the 11th point. And 12, the work needs to be peer-reviewed rigorously and highly qualified commissioners should sign it off. I think the independence of law commissions assists greatly in the credibility of that process. That open and transparent process allows people to see how and why the proposals were developed. It allows for full public input into the development of the proposals, and it provides some capacity to gauge the public acceptability of the proposals and the options. And such a process makes the final report much more robust and practical. So the takeaway message from this segment is that law commissions have forged superior methods of designing law compared with those employed by executive governments and parliaments. A robust set of transparent processes bound to produce a better outcome and better tested than plans hatched by ministers and officials working behind closed doors. Furthermore, when the product comes to be considered by the Parliament, there is a great deal more relevant information available to MPs and the public than is usually available for government bills. And if these methods are superior, then the question has to be asked, why are they not used for other legislation? The parliamentary time, that's a big problem, and I want to say a bit about that. Law commissions always struggle to get their work products enacted in a timely manner. The Australian Law Reform Commission was established in 1975. But as Gough Whitlam famously put it, the way of the reformer is hard in Australia. With your increased devolution, you may find that out here. Justice Michael Kirby, its first chair, was in that position for 10 years, and he had to innovate. The nature of Australian federalism forced Kirby to take some novel approaches, both in the methods of public consultation and in the use of the media. His methods, I think, made a permanent impact on the way many law commissions in our region and in the Australian states conduct themselves. His subsequent dual role of a high judicial office in the High Court of Australia, together with his continuing role as a public intellectual, kept the law reform candle alight. New Zealand didn't establish its law commission until 1986, having been served well for many years by a big and able Ministry of Justice and part-time law reform committees. But after 20 years of the New Zealand Law Commission, I invited Michael Kirby to give the keynote address at the celebrations we had, and he concentrated upon the problems he'd faced and the well-considered reports that didn't advance. So he said this: what can be done about the apparent logjam that remains as much an impediment to law reform action today as it was in earlier times? Consistently with our notions of a democratic and responsible parliament, is it impossible to alter the means by which law reform projects receive their appropriate share of parliamentary time? This is the central issue that requires our attention. Well, those problems can be solved in some jurisdictions, but every time a new government is elected, new priorities and new alignments occur. The obstacle to institutional effectiveness of a law commission lies within executives and Parliament. Partly as a result of the seminar at which Justice Kirby spoke, we were able at that time to solve the issue in New Zealand, and it has now been solved here. But parliamentary consideration of legislation needs to involve more input from the public. The brightest spot on the New Zealand lawmaking scene resides in the consideration by select committees of Parliament of submissions from the public on virtually all bills and the conduct of public hearings upon them. We have no upper house. I want to deal with the constitutional issues that are at play in this. There are no final victories in politics or in law reform. There is, though, I wish to persuade you, another way of storming the citadel to ensure we get better law. The citadel is Parliament, in particular the executive. In Westminster systems, the Cabinet sits in Parliament, and as Walter Bagehot famously observed in 1867, the efficient secret of the English Constitution, he described it that way, may be described as the close union, the nearly complete fusion of the executive and legislative process. Now, Bagehot's pragmatic analysis is rather different from the political theory of John Locke, writing about the time of the 1688 bloodless revolution, that the executive and the legislature should be separated. Let me quote Locke. And because it may be too great temptation to human frailty, apt to grasp at power, for the same persons who have the power of making the laws, to have also in their hands the power to execute them, whereby they may exempt themselves from obedience to the laws they make, and suit the law both in its making and execution to their own private advantage, and thereby come to have a distinct interest from the rest of the community, contrary to the end of society and government. The power of Cabinet, the efficient secret, has strengthened massively in the years since Bagehot wrote, and one doesn't have to embrace every point of Richard Crossman's view that Cabinet government has passed into prime ministerial government, or indeed Lord Hailsham's view that the British government amounts to an elective dictatorship, to wonder whether some Lockean elements may be incorporated within Westminster government to open up and change the way legislation is made so as to make better law. Westminster governments are characterised by powerful executives that exercise great sway over the legislative process. And the question is whether Parliament makes law poorly, with insufficient consideration, defective research, and not enough consultation, not enough transparency, and often missing the mark. That's what happens in New Zealand. Perhaps I shouldn't suggest it happens here, but I think it does. The lawmaking procedures are jealously guarded by the executive. Parties in opposition do not have much incentive to change them because their greatest wish is to become the government. So there exists a sort of Faustian bargain that oppositions will rail about the abuses of the legislative process by governments, but do little to change them when they have the opportunity, because the allure of great power is enticing and limiting it unattractive. The case for curbing executive power in relation to legislation can only stand, though, if the present process produces unsatisfactory legislation and alternative procedures would produce superior legislation. But there have been persistent complaints about legislation and the legislative processes at Westminster in recent years. The United Kingdom House of Commons Political and Constitutional Reform Committee published in 2013 the report Ensuring Standards in the Quality of Legislation. This was in response to repeated criticism in recent years about the quality of legislation that, despite reforms, seem to be getting worse. The Select Committee produced a long report, made a lot of recommendations. They weren't adopted, and that seems to me unfortunate. More recently, Daniel Greenberg published a trenchant criticism of trends in modern legislation. All specific instances he analyses result in increased power for the executive and less control by Parliament. His objection to the reduction in trouble taken in preparation of legislation was, I thought, particularly telling. I quote, "In the last few years, a vast range of provisions of primary legislation have been passed with enormous impact on both individuals' lives within the community and on the constitutional structure of the UK as a whole. and they have been prepared, pushed through Parliament with a lack of thought that would have been completely inconceivable a few decades ago. In the United Kingdom, of course, you have the Good Law project designed to remedy some of these deficiencies, and in the hands of Parliamentary Council, this is a promising initiative harnessing new technology. The definition of the problem stated on the website says that people find legislation difficult. The volume of it, the amendments, its piecemeal structure. The Good Law project aims to ensure that law is necessary, clear and coherent. And there's a lovely segment on the website that I like. It says this: the government is working to reform our political and constitutional system to help restore people's faith in politics and politicians. That vital aim, perhaps, could be better achieved by reforming the way the executive and parliament make legislation. Significant reform of the legislative process is required in many jurisdictions, but it is not, as far as I know, on any agenda. So we reach the last point of this lecture about what should happen next. Those interested in law reform expected a lot from the developments I covered at the beginning, and reviewing the early literature now, one can detect in it a crusading sense of legal renewal. The authors thought that a new world was at hand where change and decay in the legal system could be arrested and fixed. Law reform would fill an institutional vacuum. Legal educators would take up law reform. The dead hand of bureaucracies would not prevent progress. Law practitioners would take a vital interest in bringing the law up to date. The whole body of the law should be reviewed and infused with a sense of social purpose. These things have not come to pass. Law commissions and similar agencies are not central to government policy or its development anywhere that I know of. Tax, welfare payments and government's expenditure plans all vitally affect the community. The economic and allocative decisions of governments rank ahead of law reform. Much of government is about revenue, expenditure, economic and regulatory policy, and law reform agencies are never going to be at the centre of those decisions. The great expectations of 1965 have not been realised. The commissions have added value. They have promoted and quite often achieved important legal reforms. But the progress was not of the sort that would have impressed someone like Jeremy Bentham. No coherent philosophy for the law reform enterprise has emerged. Probably none can be devised because the law commissions occupy an awkward space between principle and expediency. We are still awaiting the golden age of law reform, and while law commissions have lifted law reform to a professional full-time activity, the vision, I think, has stalled. Some of the problem lies in the inability to rigorously and neutrally evaluate legislation. Lawmaking through legislatures is a political process. The tendency is to pass more laws but never devote sufficient resource or attention to find out whether they work, whether they have unintended repercussions, or whether the costs they impose from the point of view of compliance and enforcement are worth the benefits. Nothing in modern government is permanent, of course. Government institutions don't have a guaranteed right to succeed or even exist, and agencies can effectively be strangled by underfunding almost as effectively as by abolition. Legal nirvana is not yet on the horizon. But of course, law reform, like politics being the art of the possible, it's closely related to politics, and that's one of its problems. There are no votes in law reform and often political costs. The present record is not satisfactory anywhere. It seems plausible to think that non-common law jurisdictions do better, especially when it comes to having an orderly statute book. There is also great comfort, it must be said, as I remember my former life, for a minister in the command of a well-resourced Department of State based on the principle of ministerial responsibility that enables the minister to control the policy content of all stages of development, despite the fact that many ministers are not good at that and lack the necessary skills. Ministers tend to be reluctant, though, to allow lead advisors on matters particularly vital to them to be independent from them. The advisors and departments, too, may not wish to surrender their influence. The territorial imperative is alive and well, in my experience, in most government departments. For law reform agencies to become an independent source of advice in the production of legislation in the first rank of importance poses a challenge to conventional Westminster government's power alignments. The dance of legislation needs to be re-choreographed. Law Commission's methods have shown up the flaws in the way the Executive and Parliament make law. Since providing the law as a fundamental constitutional duty of Parliament, the remedy lies in reform of the executive and parliamentary processes. The increasing predominance of statute in the legal systems of common law countries suggests that it would be appropriate to redesign and reform the way statutes are made and promulgated to the public. New methods need to be devised to make statutes that involve openness, public participation, rigorous research and systematic process steps that law commissions have shown can produce more robust and durable laws. The stranglehold that the executive branch enjoys in most Westminster systems over the legislative design and content needs to be relaxed and made a little more Lockean. A substantial portion of the legislative process is conducted within the privacy of the institutions of the executive. That seems to be unsound and not within the normative framework of modern democratic government. More openness and transparency would likely produce a more robust legislative product that would work better and last longer. And it would also give decision makers, ministers and MPs better information upon which to base their final decisions. But once a government has decided to travel in a particular policy direction that requires substantial new legislation, then the design of that legislation should be fashioned in a different and more public way. The whole of the policy needs to be systematically developed. Ministers need to be kept out of it until the detailed material has been produced and made publicly available. Cross-disciplinary teams are essential in this. Parliamentary counsel have to be involved at the beginning, and all methods used by law commissions employed. Now, of course, there are many difficulties associated with how to implement this new vision. My suggestion for New Zealand was to erect a new legislation office in which Parliamentary Council would be the core. The whole of government standards for legislative design could be secured by having all bills prepared by this one agency following the 12 steps set out earlier, thus altering the present role of departments. The agency would be attached to Parliament, not the executive, and with some trepidation, I suggest that such a configuration could work well at Westminster. Such a process is likely to produce legislation that is better thought through and more enduring, and is more easily scrutinised in Parliament because it's been pre-cooked to such an extent. And the process would allow for much more public participation in legislative decisions. No longer would law be designed in closed and secret processes within the executive. Now, I know you've had developments here about pre- and post-legislative scrutiny, and I'm very encouraging of all of that, but not much has been achieved yet. Taking more pains with the preparation of statute law feeds into, I want to say, a very important element of good governance. The rule of law is, of course, a somewhat contested concept, but clearly statute law is at its heart. Statute law needs to be clear, effective and carefully calibrated as it can be. Lord Bingham told us that the law must be accessible and so far as possible intelligible, clear and predictable. A respected American academic, Francis Fukuyama, has reached the conclusion that three elements distinguish nations that are well governed from those that are not. Three sets of political institutions must exist in perfect balance: a competent state, strong rule of law, and democratic accountability. Such institutions, Fukuyama says, can decay. All these features are engaged in this case. Parliament as a lawmaker has an obligation to make good law by open and transparent processes. Parliament is also accountable to the public for the law it makes and should allow adequate opportunity for the public to be involved in that process. Unfortunately, the general public is, I think, ignorant about the arcane law-making processes of Parliament and the Executive. And if they did know about them, they might be disposed to agree with Chancellor Otto von Bismarck, who asked, "What do legislation and sausages have in common? One sleeps better if one does not know how they are made." Unless current lawmaking methods are reformed, decay could set in. The teaching from 50 years of law commissions is to use the methods of preparing legislation pioneered by law commissions and apply them more generally to the legislative process. Lawmaking is a function of the utmost importance to a democratic society as a whole, and it needs to be carried out as carefully and systematically as possible. Law commissions have pointed the direction for achieving better methods of making law generally. Executives and Parliament need to be persuaded they are not making law well and need to do better. To achieve such changes will, of course, require immense political leadership, and there will be great resistance. In contemporary politics, the fundamental features that matter most to the quality of governance tend to receive the least attention. So I think that, in conclusion, law commissions should be entrusted with wider responsibilities and their remits broadened to include big projects with social implications. Law commissions must cease being regarded as interesting appendages to the machinery of government and become central to legislative activities. Codification should be put on the agenda and pursued with determination. The independence of commissions remains vital to their success, and it needs to be nourished. Ladies and gentlemen, you've been very attentive to what is quite a dense lecture. Thank you.
I'm Ethan Shah, visiting fellow at King's College Policy Institute. Thank you for a very realistic overview of the situation, and quite a pessimistic one, I think. But in a sense, there was an idealism there as well around the idea of giving law commissions a bigger remit, and that did seem impractical to me, because at the moment governments give them the sort of small pieces to work on because that's what they can do. If you gave them the big policy issues to deal with, they would become like think tanks, which would be quite threatening to the masters that pay them. So how would you see that practically coming about?
I think threatening the masters that pay them is very important. I think that the power of executives in modern government, in the Westminster systems, is too great, and much greater than it used to be. And what I am saying in this lecture is that that ought to be throttled back. And I'm also saying that the way in which the executive does its own legislation is fundamentally defective, and there are also quite serious democratic deficits in the manner in which Parliament processes it. I do think you have to really get to grips with the fact that there is so much law being made, and it is so difficult for many people to deal with, that there is going to be a crisis in the rule of law if some of these things are not taken and reformed. What is not reformed is the legislative process. The fundamental message that I'm saying is that there should be fundamental reform in the legislative process, and it should be much more open and transparent, and it will require, the way you do these things is to have political leadership on them. There's no other way of doing them. You have to get someone to embrace this, to get it in a party manifesto and do it. That's how I got a Bill of Rights in New Zealand.
Yes. We've lost the microphone for a moment. Could we have the microphone at the front, please?
Okay, thank you. Mazen Zaki, Lawyers Secular Society. You mentioned the work of Francis Fukuyama
he talked about the accountability, bureaucracy, and the rule of law, but he also was worried that all these can be subject to capture by vested interests. And one of the problems in all legislatures, whether democratic or otherwise, that the legislature is often made up of lawyers. So could you comment on that feature of legislation?
I think that capture is a big thing. In the program I did on the sale of liquor in New Zealand, the lobbyists were very active when the report came on in getting it watered down. There were 154 recommendations, 134 of them were followed, but the 3 or 4 that would have made the most difference were not followed. I do think that it is true that the real problem with modern social democracies is that the forces of capital are not easy to regulate, and they have a lot of access to the political system, and that access is often behind closed doors, and that is a problem. And you have to, like anything else, regulate it.
Yes. Please. Time for one last question, I think.
Hello, yes, my name's Tim Blackman. I'm a governor at the Legal Education Foundation and Vice Chancellor at the Open University. Absolutely fascinating talk, thank you very much for it. You made a comment that law made by law commissions is better than law made by governments. So I'd be interested to know whether that's based on evidence, like comparisons and so on. If it is true, is it a recipe for societies run by technocrats rather than by elected politicians?
No, I don't think it is a question of running it by technocrats. I think that I'm not suggesting that governments don't take the decisions. I'm just saying that the work that is done in the background has to be done systematically and it must not be done hurriedly. I'm looking, actually, as I say this, at the former Speaker of the House, Sir Lockwood Smith, who's our High Commissioner here, and he knows very well that quite often they pass legislation quite quickly. It's a great temptation in a parliament with only one house. Speed produces bad legislation. There's quite a lot of it around, and there is very little ability to know what is going on within the executive branch of government when they are making it. The law commissions, it's all open, it's all transparent, and that means that you can tell what's happening. I've always thought that Louis Brandeis's remark that sunlight is the best disinfectant is quite right.
We'll take one last question there then, please. One last question there, and then we'll draw to a close.
James Hines. One generally gets the impression that law reform is easier with perhaps a younger state which is more nimble and flexible. To what extent is 800 years of Magna Carta a millstone?
Well, the British Library has a magnificent presentation on Magna Carta they went to yesterday, and it was just terrific. And you can see how Magna Cartas emanate into many legal systems of the world. One provision in Magna Carta is still part of the law of New Zealand, and indeed I provided some legal advice only 3 weeks ago that it might apply to one particular problem. So, but when I come here and look at Magna Carta and then look at Richard III, about whom many people had forgotten, but now, the heritage of your history sits very heavily upon you. And that is very obvious from the number of statutes that you have to repeal. But let me tell you, New Zealand's a pretty old democracy. We've been going a long time. We've got a lot of law. We've got 100,000 pages of it. It's too much. We can't find it. We keep adding to it. We never weed it out. This is a big problem. But I think that you can handle this in the United Kingdom. You've got a highly educated group of people, you've got a great civic culture, you've got an active media. Why can't you? You shouldn't feel intimidated by your own history.
time to draw the formal part of the proceedings to a close. First, may I thank Phil Hodgson and the team of volunteers from the Law Commission who've made the arrangements for this evening. Phil Hodgson's been organising this event for over a year. We're very grateful to you, Phil. Secondly, may I, on your behalf, thank Geoffrey for such a stimulating and insightful lecture, which I'm delighted to say is going to be published in the Law Quarterly Review later this year. This was indeed a vision of law reform by someone who's played with great distinction on both sides of the street, as a politician and as a lawyer. It's a very bold vision. I hope you don't think, Geoffrey, that we've been too timid, but I have to say that you're absolutely right when you say that the Commission's successes over the last 50 years have been essentially in the area of lawyers' law. We have, in fact, rather enjoyed our rich but limited diet. Your remarks this evening are certainly an inspiration to us at the Law Commission as we embark on our second half-century. Like all law commissions, we'll be keen, in your words, to secure more political commitment, more resources, and more parliamentary time. And I promise you, you can rely on the Commission to employ remorseless advocacy to those ends. Thank you for such a fascinating lecture. We're very grateful to you.